what's the best way to go to SBA and increase our legal expense budget?
Well, the sooner the better, and there is a little bit of wiggle room on your litigation plan and the expenses there. I can't remember what the exact number is off the top of my head, but you do have a little bit of wiggle room. I think it's 10%. So if you're still within those bumpers, you're okay. If you think that you're going to be outside of those bumpers, you should submit an amended plan to the SBA as quickly as possible.
Okay. Companion loan question. If both loans are SBA, with the first loan having a first and the second loan having a second, can expenses be allocated to just one, or do we have to split the expenses between the two loans?
That's a good question. Because the second position loan will ride on the coattails of the first in a lot of respects, but will likely be out of the money. So have to look at that from a more detailed perspective on the specific facts. But my suspicion would be that if you had a first position loan and they were both SBA, that you could put all the expenses under the first position loan. It's particularly in a case where the second position loan is going to be out of the money entirely, or out of the, is undersecured entirely.
Great, thank you. What are the benefits and disadvantages of getting payments outside of the bankruptcy plan?
Well, payments outside of the plan, again, you're going to be subject to court approval, but you have the flexibility of having cut your separate deal that's outside of the plan approval process and all the disclosures that are entailed with that as well. So in instances where you may not necessarily want everything out there as far as the details on your deal, you can get paid outside of a plan. It happens commonly in Chapter 13 cases, but in a Chapter 11 case, payments outside of the plan, you will need to disclose to the bankruptcy court, but it's certainly a viable way to go if you want to keep your deal outside of the plan voting and plan scrutiny process.
Should instant raise for the benefit of the lender, does SBA need to approve carve-outs?
Yes. Or excuse me, carve-outs for general unsecured creditors. In a Chapter 7 case where trustee is going to liquidate your collateral for you, they typically require a carve-out for unsecured creditors. We handle that. I don't believe that there is a specific requirement or a specific provision of the SOP directing that, but we handle that in the liquidation plan or in a litigation plan to make sure that we get approval of that. Just because it's something that's not necessarily commonly dealt with at the Guarantee Purchase Center. So we want to sort of be upfront with that, either in the litigation plan or the liquidation plan.
Great. If the bankruptcy notice says not to file a proof of claim, do you still file it because it is required by the SBA?
Well, it's not required by the SBA. The language in the SOP is permissive, but so you're not required to do all of those things, but if the need arises, you should do those. The reason that I strongly suggest you file a proof of claim in every bankruptcy case is that it's cheap and it doesn't really cost you anything and it covers your bases. So in that context where you have a bankruptcy notice that says don't file a proof of claim unless you're told to, that's great and you can ignore it. But if somewhere down the line additional assets are recovered or found, there could be a re-notice of that case and a notice that you need to file a proof of claim. If you miss that for some reason, that second notice, because you already have it in your mind or you have the file closed out, and you get that notice, you run the risk of blowing the bar date there. So even in cases where it's not specifically required, if the dollar figures justify it, it typically advised to file a claim anyway, because it doesn't cost you anything and your bases will still be covered.
Another experience question. If the SBA didn't get notification prior to the vote of the reorganization plan, has the lender jeopardized the guarantee of the 7A loan, or what would the remedy be, assuming the plan has been approved and put in place and the borrower is performing the plan? Okay,
so here's a scenario where the lender has not been apprised of the plan voting process or their
SBA,
ballot
SBA wasn't apprised, correct?
Yeah. Prior to the voting deadline, they don't vote. Plan gets approved, and now they're stuck. Again, in the SOP, filing or voting on a plan is something that's encouraged, but it's not required. So in a situation like that, you can go back and object to the plan on the basis that your notice was inadequate. But that being said, since it's not a requirement for you to vote on a plan, if you have something along those lines where you were not apprised at all, that's something that I would memo in my 10 tab.
Let's assume another scenario. Let's assume that the lender approved the plan and never notified SBA.
Well, you can vote in favor of a plan without SBA approval in any other circumstance other than the one where we discussed, specifically mentioned in the SOP, where it's going to compromise the principal balance. And in any other circumstance, it's not covered by the SOP directly. So if you vote in favor of the plan erroneously and don't provide notice,
there was a cram down. There was a cram down on the principal in this case.
Yeah. So if you inadvertently voted in favor of the plan
with a cram down,
that's with a cram down, that's something you need to address because it's typically very difficult for you to. I can't think of the procedural machinations you need to go through to withdraw your vote and vote in favor of the, and change it from a yes to a no vote. So you would typically be stuck with that in the bankruptcy side of things. So that's something that you would have to address proactively with the SBA in your 10 tab and say, explain the reasons why. Because if you got the plan voting and you're apprised, it's very difficult in all of these scenarios. It's very difficult to get to the plan voting stage without having notice. So you run a very difficult burden of proof and burden of explanation as to why and how you didn't get a
I think what you're saying is come clean, detail, be fully transparent, and lay it on the line with what's going on.
Absolutely.
Okay, last question. Thank you very much, and I apologize for going over a couple minutes, but the questions are great. All right, let me just read it. On a 504 deal, is there any restrictions against foreclosing on our first lien and then selling the property to the original borrower at a foreclosure sale? This, of course, wipes out the CDC's second. I reviewed our third-party lender agreement but cannot find the language that addresses this issue. My borrower filed Chapter 11. The bankruptcy was dismissed. The CDC has been properly notified, but to maximize our recovery, we'll need to foreclose.
Okay. Well, I'll address the first question first. What's my experience with this? I've never had that come up directly. But from a bankruptcy standpoint, if the bankruptcy case has been dismissed, there is no bankruptcy overlay in that situation. A dismissed bankruptcy case is as good as if the bankruptcy case never happened. So there's no bankruptcy ramification. So you are now back in your straight 504 liquidation analysis under state law, and that would deal. It could hinge entirely on issues of state law. So if someone wants to discuss that in greater detail, I'm happy to do so offline. But there's a lot of other questions that would need to be raised as far as ability and right to collect on a deficiency and those sorts of things under state law in that context that we need to address. Okay,
and I promise this is the last question, but it sounds like a short answer. Is there a statute of limitations to file a proof of claim if never notified, or do rights expire once the case is wrapped up?
If you've never been notified of the claim, if you've never been notified of the case, and you should have been, you are exempted from the discharge. So the discharge injunction doesn't apply to you. So you could boldly assert your collection rights and assert collection of the claim. Typically, the response, whether they're right or wrong, I would suspect the debtor entity would assert the automatic stay and the discharge injunction, and you would need to be back in bankruptcy court to address those issues. But from a technical standpoint, if you aren't provided notice, you are not discharged.
Great. Joseph, the contact screen. I apologize if I missed any questions in wrapping up here. Greg Kupniewski, Starfield and Smith, thank you very much for an excellent presentation. This concludes today's webinar.
Thanks, everyone.